The Supreme Court has just delivered the most devastating blow to any sitting Prime Minister in modern British history. Keir Starmer's government has been struck down over a massive financial scandal that goes far deeper and far darker than anyone outside the inner circle knew. This isn't about policy disagreements or political point scoring. This is about money, serious money, disappearing into places it should never have gone, with contracts awarded to people who had no business getting them, and a web of financial misconduct so extensive that the highest court in the land had no choice but to intervene and declare the entire operation unlawful. The ruling that just came down exposes a system of corruption that would make banana republics blush. A deliberate scheme to funnel taxpayer money to cronies and connected insiders while lying to Parliament and the public about where that money was going and what it was being used for. We're talking about hundreds of millions of pounds, possibly billions when all the contracts and deals are fully investigated, money that was supposed to go to public services, to healthcare, to education, to the things that actually matter to ordinary British families. Instead, it ended up in the pockets of consultants who delivered nothing, contractors who had suspicious connections to government officials, and firms that seemed to exist primarily to extract public money through sweetheart deals that bypassed normal procurement processes. The Supreme Court didn't just rule that some paperwork was filed incorrectly or that some minor procedures weren't followed. They found systematic unlawful conduct, deliberate circumvention of safeguards designed to prevent exactly this kind of corruption, and a pattern of behaviour that showed conscious intent to hide what was really happening from anyone who might ask questions or demand accountability. This is the scandal that Starmer's team has been desperately trying to keep buried. The truth that explains why he melted down when questioned about consultant spending during PMQs, why he threatened Tom Hardy for asking about where arts funding really went, why his government has been so aggressively secretive about financial details that should be public information he knew his inner circle knew, and they've been operating on the assumption that they could keep the lid on this until it was too late for anyone to do anything about it. But the Supreme Court just blew that lid sky high, and what's underneath is going to destroy careers, end political futures, and potentially result in criminal charges for people who thought they were untouchable. The financial scandal at the heart of the Supreme Court ruling centres on a scheme that was breathtaking in its audacity and brazen in its execution. Shortly after taking office, Starmer's government initiated what they called a comprehensive review of government operations and efficiency. They claimed this was about making government work better for citizens, about identifying waste and improving service delivery, about modernising systems and processes that hadn't been updated in decades. It all sounded reasonable and even admirable on the surface, the kind of thing that reform-minded governments do when they come into power promising to fix what's broken. But that efficiency review was actually a cover for something much more sinister, a mechanism for awarding massive contracts to private consulting firms without the normal competitive bidding processes and oversight that are supposed to prevent corruption and ensure value for money. The firms that received these contracts had one thing in common: connections to people in Starmer's government or to the Labour Party more broadly. Some were run by former party officials. Others employed spouses or family members of current ministers. Several had made substantial donations to Labour during the campaign. The pattern was unmistakable to anyone who looked closely, which is exactly why the government works so hard to prevent anyone from looking closely. The contracts were structured in ways that made them difficult to track through normal transparency mechanisms. They were often broken into smaller pieces that fell just below thresholds that would trigger additional scrutiny. They were classified under categories that made their true nature and purpose unclear. And they were justified using vague language about strategic advice and operational transformation that could mean almost anything or nothing at all. Civil servants who raised concerns about these contracts were sidelined or pushed out entirely. Procurement officials who insisted on following proper procedures found their authority overridden by political appointees who had the power to make final decisions. Internal auditors who flagged of irregularities were told to back off, that these matters were being handled at the highest levels and didn't require their involvement. The message throughout government was clear: don't ask questions about these contracts, don't dig into where the money is going, and definitely don't create any documentation that might later prove embarrassing if it became public. This systematic suppression of normal oversight and accountability should have been a massive red flag. But it was done gradually and quietly enough that no single person saw the full picture of what was happening. Everyone knew their little piece seemed wrong, but they didn't realise that their little piece was part of a massive scheme affecting billions of pounds of public money. The Supreme Court case originated from a whistleblower, a mid-level civil servant who had been working in the procurement department and had started to notice patterns that didn't make sense. Contracts being awarded to firms that didn't appear to have relevant expertise. Renewals being approved despite lack of deliverables or measurable results. Questions about value for money being dismissed or ignored. This civil servant did what they were supposed to do. They raised concerns through internal channels, documenting what they were seeing and asking for explanations. The response was swift and brutal. They were accused of being disloyal, of not understanding the complexities of government operations, of causing problems where none existed. They were moved to a different role where they would have no visibility into procurement decisions. And when they continued to raise concerns, they were subjected to a disciplinary process that seemed designed to intimidate them into silence. But this civil servant refused to be silenced. They gathered every piece of documentation they could access, every email and memo and contract file that showed the patterns they'd observed. They consulted with lawyers about their options and their protections as a whistleblower. And then they went public, providing their evidence to investigative journalists and to legal advocacy groups that specialise in government transparency and accountability. The journalists who received this information initially struggled to make sense of it because the scheme was so complex and so deliberately obscured. But as they dug deeper, bringing in forensic accountants and legal experts to help analyse the contracts and the money flows, a picture emerged that was shocking even to people who thought they were beyond being shocked by government corruption. Hundreds of contracts worth hundreds of millions of pounds awarded without proper competitive processes, delivering questionable or no value, benefiting firms with clear connections to the government, and all of it hidden behind layers of bureaucratic complexity and deliberate obfuscation. When the first stories started appearing in the press, Starmer's government went into full denial and attack mode. They claimed the reporting was inaccurate and politically motivated. They attacked the whistleblower's credibility and suggested their motivations were suspect. They insisted that all contracts had been properly awarded and that suggestions of impropriety were baseless conspiracy theories. But they also refused to provide detailed information that would allow independent verification of their claims, citing commercial confidentiality and other standard excuses that governments use when they want to hide information. This response only intensified scrutiny because if the contracts were all proper and above board, why not just release the details and prove the critics wrong? Legal advocacy groups took the evidence from the whistleblower and the journalists' investigations and filed a case challenging the lawfulness of how these contracts had been awarded. They argued that the government had violated procurement regulations designed to ensure fair competition and value for money. They claimed that the lack of transparency and the circumvention of normal oversight processes was unlawful. And they demanded that the courts intervene to stop the contracts and to force the government to account for how public money had been spent. Starmer's government fought the case aggressively, using every legal tactic available to delay proceedings and to prevent disclosure of information. They claimed that the details of the contracts were protected by various privileges and confidentialities. They argued that courts shouldn't second-guess government decisions about how to procure services. They tried to have the case dismissed on technical grounds before it could get to the substance of the allegations, but the evidence was too strong and too well documented to be dismissed. And the legal arguments about unlawful procurement were solid enough that the courts allowed the case to proceed. As the case worked its way through the system, more evidence emerged through the discovery process. Government officials were forced to turn over documents they'd been hiding. Email trails showed deliberate efforts to circumvent normal procedures. Internal memos revealed that concerns had been raised and ignored. The picture that emerged was even worse than what the initial whistleblower had documented, showing a systematic effort to use public money for what looked very much like a patronage scheme designed to reward political allies and build a network of obligated firms that would support the government in various ways. The Supreme Court hearing itself was extraordinary, with the government's lawyers struggling to defend conduct that looked indefensible once laid out in detail. The justices asked pointed questions about why normal procurement procedures hadn't been followed, why contracts had been awarded to firms with obvious political connections, and why the government had been so resistant to transparency about spending that should have been public information. The government's answers were evasive and unconvincing, relying on claims about efficiency and urgency that didn't stand up to scrutiny when examined against the actual timeline and circumstances of the contracts. The justices pressed particularly hard on the issue of whether there had been deliberate efforts to hide these contracts from normal oversight, noting that the structure and categorisation of the spending seemed designed to avoid triggering reviews that would normally apply to contracts of this size and significance. The government's lawyers had no good answer to this, falling back on claims that everything had been done in good faith based on legal advice, but unable to produce that legal advice or to explain why, if they'd received advice that their approach was lawful, they'd been so secretive about it. The advocacy group's lawyers systematically dismantled the government's defences, showing that the claimed justifications for bypassing normal procedures didn't hold up, that the firms receiving contracts often had no relevant expertise or track record that would justify their selection, and that the lack of deliverables or measurable outcomes suggested these weren't genuine service contracts, but rather were mechanisms for funneling money to connected parties. They presented evidence of the connections between contract recipients and government officials, showing a pattern that went far beyond coincidence. And they demonstrated that civil servants who had raised concerns had been silenced or pushed out, suggesting consciousness of guilt rather than good faith administration. When the Supreme Court issued its ruling, the language was unusually strong and critical. The justices found that the government had systematically violated procurement regulations designed to ensure competitive processes and value for money. They ruled that the circumvention of normal oversight and transparency mechanisms was unlawful, and they specifically criticised the government's efforts to hide these contracts and to prevent scrutiny of how public money was being spent. The ruling noted that the pattern of awards to politically connected firms, combined with the lack of normal competitive processes and the suppression of internal concerns, created a strong inference of improper motives that the government had failed to adequately rebut. Most devastatingly, the court found that the government's conduct showed contempt for the principles of proper financial stewardship of public resources and for the transparency obligations that are fundamental to democratic accountability. This wasn't just a finding that procedures weren't followed correctly. This was the highest court in Britain, essentially accusing the government of running a corrupt patronage scheme using taxpayer money and then lying about it to cover their tracks. The immediate political impact was seismic. Opposition parties called for Starmer's immediate resignation, arguing that a Prime Minister whose government had been found by the Supreme Court to have engaged in systematic, unlawful financial conduct had no credibility or moral authority to continue in office. They demanded criminal investigations into whether the conduct crossed the line from administrative wrongdoing into actual fraud or corruption. They called for a complete audit of all government contracts awarded since Starmer took office to determine the full extent of the financial scandal. Media coverage was universally damning, with even outlets that had previously been sympathetic to Starmer's government expressing shock at the scale and systematic nature of what the Supreme Court had uncovered. Investigative teams mobilised to dig deeper into the contracts and the firms that had received them, finding additional examples of questionable awards and deepening the sense that what had been exposed so far was just the tip of the iceberg. Financial analysts calculated that the total amount of public money involved in questionable contracts could exceed £2 billion once everything was fully investigated, making this potentially the largest financial scandal in modern British political history. The human cost of this corruption was also becoming clear. Money that went to politically connected consultants was money that didn't go to public services. Journalists found examples of hospitals that had been denied equipment upgrades, while millions went to consulting firms with no healthcare expertise. Schools that had been told there was no money for needed repairs, while contracts were awarded to firms providing vague advisory services that produced no visible results. Communities that had seen libraries and youth centres closed due to budget constraints, while billions flowed to the patronage network that Starmer's government had created. This wasn't victimless financial irregularity. This was corruption that had direct harmful impacts on ordinary British citizens who depended on public services that were being deliberately starved of resources so that money could be funneled to political cronies. The response from within government and from Labour MPs was panic mixed with denial. Some tried to continue defending Starmer, arguing that the Supreme Court had overreached or that the ruling was being mischaracterised. But these defences collapsed under the weight of the actual judgment, which was clear and unambiguous about what the government had done and why it was unlawful. Other Labour MPs went silent, refusing to comment or making vague statements about needing to study the ruling before forming opinions. This silence was itself damaging because it suggested they knew there was no good defence, but couldn't bring themselves to publicly criticise their own leader. A few backbenchers broke ranks to call for accountability and for full investigations, risking their political careers to stand on principle. These MPs were immediately attacked by party loyalists who accused them of disloyalty and of helping the opposition, but public reaction was strongly supportive of those who were willing to put integrity above party politics. Civil servants who had been involved in raising concerns or who had been pushed out for questioning the contracts started coming forward publicly, now protected by the Supreme Court ruling that vindicated their concerns. Their accounts of how the scheme had operated, of how dissent had been suppressed, and of how political pressure had been used to override normal safeguards, painted a picture of a government that knew exactly what it was doing and that had deliberately created a system to avoid accountability. These first-hand testimonies were devastating because they came from career public servants with no political agenda, people who had dedicated their careers to proper government administration and who had been punished for trying to do their jobs correctly. Starmer himself gave a press conference attempting to address the ruling, and his performance was predictably disastrous. He claimed that the government had always acted in good faith and that any irregularities were unintentional mistakes made in the rush to deliver on campaign promises. This explanation was immediately torn apart by journalists who pointed out that the Supreme Court had found systematic violations and deliberate circumvention of safeguards, not innocent mistakes. He tried to blame civil servants for not properly implementing procurement procedures, which was both factually wrong and morally reprehensible, given that civil servants who had raised concerns had been silenced or pushed out. He refused to commit to any ministerial resignation, saying he needed to review the full judgment before making personnel decisions, which everyone recognised as stalling to avoid accountability. He attacked the opposition for politicising what he claimed was a complex administrative matter, ignoring that the Supreme Court had found unlawful conduct involving billions of pounds of public money, which is about as serious as political matters get.